Going live now. Waiting for more followers to join. Hello, Aditi. Welcome to our Turkcha's live online. I see Dilek, and she's our lawyer, and I'm going to add her to our live session. Hopefully, please bear with us. Hopefully, she'll be here in a moment. Hello, Dilek. Dilek. I'm sorry,
Hi.
Fatma. Selam.
It's okay.
Hi.
It's both first names.
Yeah, I know, like Mrs. Dilek. It's very formal. Yeah, start while waiting for more people to join in. I guess I'll talk about Turkcha. If you're here, you probably already know what Turkcha is. Turkcha is our own Washington-based organization that helps immigrant support immigrant women that lives around Seattle area. So for achieve this aim, Turkcha organizes some workshops and informational gatherings. But these gatherings used to be in person before the pandemic. Now they are online. It's like everything else to keep safe. So I'll be moderating today's event with Fatima Dilek Dabagoglu. So I'll just read a little bit introduction about her so that you'll get to know her better. Fatma was born and raised in Germany, moved to US in 2001 for a study abroad program, and studied political science at the University of Washington, and later received her law degree from Seattle University School of Law. She passed the bar exam in Washington in 2015 and worked as a prosecutor both during law school and after passing the bar. She opened her own practice in 2017. As a fellow immigrant, she wants to make sure that women have access to knowing their rights and available resources. While she focuses on the criminal defense and car accident injuries, she has done many of these protection order cases and helped train other attorneys in handling these cases. Thank you so much. I guess we'll continue, and this will be recorded if you don't have any technical difficulties, and will be available later on. So if you joined later or hasn't started from the beginning, you will be able to watch this through other means. So did you want to say something to our viewers, Fatma? We can start.
No, just that it's a very sunny day, and so whoever's joining, we appreciate it. It's just information. I think one thing that I have to say always before we start it is that I don't represent anybody. I can't give legal advice here specifically to like specific viewers. And so what I'm talking about is not supposed to be considered legal advice. Because every case is different and everyone has different circumstances, and this is supposed to just help just have access to the resources and just kind of a step-by-step on what you need to do, and how do you know which form to apply for. But thanks for hosting it. Thanks for organizing this.
Yeah, thank you. Yeah, that's a great point. So hopefully it will be helpful, but let's not take it as a legal advice. You need to consult for every single case. Also, I want to say one more thing. Today is in Turkey Women's Rights Day, because 1934, December 5th, that was the date that women got the right election to vote in elections and being able to elect it in Turkey. So it's the Women's Rights Day, so which was a great surprise to me, and I'm super happy that this event is happening on this meaningful day. Well, without further ado, so that we won't run out of time, I'll start with the questions. Okay, so Fatma, what is a domestic violence protection order? Can you explain to us?
So yes, so as a victim of domestic violence, the person who's applying for domestic violence is considered the petitioner. And you have the right to file a petition of domestic violence protection order against the abuser. And so the abuser in this form, in this application, will be considered the respondent generally. And so when I talk about petitioner and respondent, the petitioner is the person who's seeking relief from, a domestic violence relationship. There does not have to be, unlike a criminal case, when you apply for a civil protection order, there does not have to be like an actual arrest with a police officer. There doesn't have to be a police report or any criminal charges filed. And that's how a protection order is different from a no contact order, which would be filed in a criminal case.
Thank you. Our next, by the way, more people joined. We'll be recording this and you'll be able to see it. If you missed the first question, you'll be able to catch that later on online. And if you have any questions, if you write that, I'll try to catch through the comments. Second question, are there different types of protection orders?
There's many different kinds of protection orders. There's an anti-harassment order, for example, which can be used for, which we're seeing a lot right now for neighbor disputes, for example, because, you're not considered to be in a domestic relationship. There is stalking, anti-harassment orders. So the person who's filing for these has to look for the definition and make sure that if they're filing for a domestic violence protection order, that they would fall in one of the categories of what it means to be in a domestic relationship.
All right. What specifically makes it domestic?
So domestic means specifically in this case, it can be a spouse, so husband, wife. It can be a former spouse, former husband, former wife. People who have children in common, adult people who are related by blood or by marriage, so siblings or husband, wife again, and then adult persons who presently live or used to live together. It can also be a person who has a biological or legal parent-guardian relationship.
Mm-hmm. Like adopted or foster care, maybe?
Adopted. Yeah, okay. Adopted is included. There are some other categories as well for, like if you're 13 years or 16 years old, but that would be too confusing right now, so I won't get into that.
Okay. Yeah, like a reminder, this is not a legal counsel. You just like to inform. Fatima, exactly. I'm not informing, I'm just asking questions.
Yes,
okay.
Thank you.
Who can file a domestic violence protection order?
So it's anybody who would fall into one of those categories. Husband, wife, ex-husband, ex-wife. Roommates are also included. So if you live together, but there's no relationship as far as, being related by blood or by marriage. So if you're in a roommate situation as well, that would fall under the category of domestic violence.
Interesting. Okay, so what does a protection order do?
So legally speaking, and we have to remember that I want to focus back on the seminar that we had a couple weeks ago, where we heard about just generally what domestic violence is. But a protection order protects the person who applies for it from having any, from being protected from the abuser. So the person who is applying for a protection order will put, and we'll go into detail in a little bit, but we'll put details about who they want to be protected with through an emergency hearing, which is held. It's called ex parte. It just means it's held without the other person being present. It will protect you from that person being able to contact you. So specifically, the respondent can't get in touch with you. They can't harass you. They can't call you. They can't send you something in the mail. they also can't contact you through third parties. So, you know, I can't tell somebody to tell the petitioner such and such. So that would actually be considered contact as well. And so any kind of contact is prohibited with a protection order. It can also award temporary custody. I don't want to go into too much detail about that because then we're going to start talking about too much family law, but it'll be on a temporary basis. It could, in some cases, the judge can impose some kind of treatment to the respondent. So they can say, I need you to go and, you know, take these specific classes as part of this order. It can prevent the respondent from, if you have children, taking the children out of state. And then, you know, of course, any act of abuse is prohibited with this order.
Okay, yeah. Again, if any of our viewers have questions, type it and I will try to catch it and maybe at the ask at the end. So I'll continue with our the interview. Is there a difference between a criminal and civil protection order?
There is. If we have time, and it, you know, looks like we're going pretty fast, so it sounds like we're gonna have time.
We're going pretty fast, so yeah, I think it's okay to take your time. Looks like we are almost.
I know. So a criminal. So there is it. So the difference between a civil case and a criminal case is a criminal case is initiated by the prosecutor's office. So they're the ones who are basically representing the state or the city, and they're considered, you know, they're supposed to protect the rights of, you know, victims or the people who can't protect themselves. Criminal cases include jail time, right? Loss of liberty. And so civil hearings, you know, there's no jail time unless the judge sanctions you, you know, for acting in a certain way. But civil hearings are generally at a lower burden as well too. So you have to prove only by a preponderance of evidence is what it's called, and criminal cases have to be proven beyond a reasonable doubt. So you know, I don't want to confuse people too much with going into too much legal jargon, but a no contact order that's part of a criminal case is really not tied to the victim directly. So it starts with the victim, you know, either reporting a crime or somebody on behalf of the victim calling 911 and reporting a crime. And then, you know, police will get involved. A police report will be initiated. Sometimes there's people being arrested, you know, when the officers come to your home. But for a civil protection order, it's basically just, you know, going to court. And, you know, because of COVID right now, this is all done online and via Zoom as well. But civil hearings are generally initiated by, you know, the person themselves. Criminal hearings, even if the victim in a criminal hearing is not willing to cooperate or go forward, a lot of times the case will still continue, even if the person is not on board. So the difference would be, you know, applying yourself in a civil protection order versus the court imposing no contact with the victim in a criminal case.
Mm-hmm. Actually, there was one more question I wanted to ask you. I forgot to ask that because I was so excited to be live. Is there a specific demographic with this domestic violence? Have you seen?
You know, that's a really good question because, you know, a lot of times, I should say this, you know, also circling back to the previous seminar that was done a couple of weeks ago, you know, where we heard about the wheel of how domestic violence can affect people. Generally speaking, when people are in a domestic violence situation, it doesn't happen overnight, right? If it did, then, you know, people would generally notice. And so the abuser generally will, you know, plan accordingly, just kind of, you know, slowly start with little things where, You know, the victim generally thinks, you know, this is done, you know, for my best interest, or, you know, you know, this person would never do something to hurt me. I'm sure they know, you know, better in this case. But because it starts so slow, and because, you know, it's literally just like, you know, over time, when it gets to the point of actual, like, you know, abuse that, you know, you start noticing as a victim, until it gets to that point, you don't generally notice it. So it can be any age, it can be any education. It's a very sensitive, personal, emotional area that, you know, we have our professional lives where we're in a certain way and that's what we stick to. But, you know, behind closed doors, there's a lot that can happen that, you know, others are not aware of, and you might, you know, you as the victim yourself might not be aware of either. So unfortunately, it can happen to anybody. You know, what I tell you know, people when they get in touch with me about this is that there's nothing to be embarrassed about. Uh, this happens, you know, it can happen to anybody. It doesn't mean that you're uneducated. It doesn't mean that you're not cultured. It doesn't mean you didn't know what you were doing or you were not smart enough to get out of it in time. It's just basically, uh, you know, part of life that happens, and taking steps to protect yourself, and, you know, a lot of times protecting your children is, you know, something that, you know, you should do without feeling embarrassed about.
It's a very good point. I mean, yeah, domestic violence victims, unfortunately, they think, oh, it can't be happening to me. It's important to recognize it could happen to anyone. Thanks for thanks for reiterating that.
Right.
Uh,
Right. A lot of
yeah,
times people will blame themselves, right? It's all about the self-blame.
yeah,
You know, had I not done this, you know, I started this. If you know, if I talked in a certain way, or if I behaved in a certain way, he wouldn't be mad at me, she wouldn't be mad at me. You know, those are very, very common feelings. And so it's nothing to, you know, feel discouraged about when it comes to protecting yourself and those that you love.
yeah. It's important to, yeah, also know how to
Hmm.
protect yourself as well. It's great to know that
Yeah.
there's options. And Washington State, I guess, is one of the. Well, I guess you wouldn't be able to know the other states, but I think Washington State is one of the more progressive states in that case. Protects the victim.
We are.
Yeah. All
Yeah.
right. Let's. How do people go about getting a civil protection order themselves?
So this is the main part of the seminar. I will walk through it slowly. I didn't create slides because I don't want to. A lot of times when we look at slides and when we try to follow things, I myself, just from personal experience, I usually do screenshots when I do something like this on the phone to remember to look at it later, and then I just never do. And so, you know, and this is being recorded. It can be listened to again, as you said earlier. So um, just giving out like the general points of like what you need to do. So before COVID, a person, a petitioner, so a victim, could walk into the closest court that they live. So it's called the jurisdiction where they live. So for example, if I live in Northgate, for example, I can go to court in Shoreline. It's Shoreline District Court. If I live downtown, I can go to King County Superior Court or District Court. If I live in Redmond, I can go to Redmond Municipal Court, which is also the district court there. And so you can walk into the closest court where you live, and you can ask for an application packet. It generally will look, you know, similar to something like this. I just printed it out from the King County website, but you know, it's multiple pages. It looks very overwhelming, but it's not that much information. It's all information that you can basically answer. Um, so for domestic violence cases, even if you walk into, you know, the closest court to you, which happens to be like a smaller court, which is called a city court, municipal court,
Mhm.
a lot of times the judge will hear you, but then transfer the case to superior court. Superior Court is, you know, they have more access to resources, and generally Superior Court will have, you know, like felony cases or, you know, other civil cases that they can hear, and the judges a lot of times, you know, see these all the time, and so, you know, they can have more experience sometimes. Although judges, you know, like the judge in Shoreline or in Redmond, they will hear your case if you walk into court. So the first step you do, you know, besides, you know, from taking safety steps for yourself to make sure that, you know, you're taking certain steps and you have a support community and group to help you with the first step, is to walk into court, and you can go up to the clerk's window. You know, generally it's right after security. And then you just ask for an application for a domestic violence protection order. They generally come together, and I suggest that, you know, if possible, go to a superior court if it's not too far, because superior courts will have people called domestic violence advocates. They can't give you legal advice, but they will sit down with you and they will help you fill out the forms completely, because it can be overwhelming. You know, it's difficult sometimes to look at a form like this where you get a packet of, you know, 10, 12 pages and then realize that you don't know which box to mark and which box not to mark. So if you just Google, if you live in King County, you can Google King County Domestic Violence Protection Orders. And then you can go to the page and the forms are there. If you get overwhelmed, there are phone numbers that you can call that they provide also on the website. Let me... So just briefly, you know, I can go over some of the things, you know, on the form, just so people have kind of an idea of what, you know, what to expect and what information, you know, they need to include. But like I said earlier, if you are the victim, you are the petitioner. So the petitioner is, you know, the person filing for this. Respondent is the person that you're seeking protection from. On the form, the court will initiate that number, so you don't need to fill in anywhere where you don't know what to do. Like I said, if you go to King County or Snohomish County Superior Court or Pierce County Superior Court, they will have advocates there that you will get assigned to, and they can also help you, you know, not just filling out the form, but also with resources. Because worker education background, so you know, they're very well trained in helping you with this. You know, the boxes literally say, I am a victim of domestic violence committed by the respondent. That will be checked. The victim, which is you, the petitioner, lives in this county. You just check that box too. It's literally just like checking boxes for a while. And then you will specify what your relationship is. So it says the victim and the respondent are either intimate partners or you know, family or household members, or you know, like roommate situation. You can specify it in the form. If you have minors living with you, such as, you know, children that you also want to protect, the next page will have information about, you know, what's the first name, last name, age, and how are you related to the minor. So you're the father or you're the mother. And then you will say who that person resides with on the form. Like I said, if you look at the form, it's not as overwhelming as you think when you first look at the form, and, you know, there's just a bunch of writing on it. And then the request for protection order will say, you know, I would like the respondent to be restrained from, you know, causing any physical harm, bodily injury, assault, you know, harassment, threat, stalking of me and these minors. And then, you know, if there's minors, then that box will be checked. The person is restrained from cyber stalking, surveillance, keeping, physical or electronic, and any other means of monitoring. So it's not like you can hire, the abuser can hire a private detective and start following you. That would be considered surveillance. So that would be considered violating the order. That the person be restrained from coming, near me or my minors, or the minors living with me, to my workplace or shared residence, my school, if the person is still in school, daycare, or any other information. There's also an other box where, the petitioner knows that the abuser is aware of this place, and you can prevent them from coming near any of those places. Usually it'll be 500 feet, and it has to be knowingly coming to these places. I'm gonna stop real quick to see if you have any questions before I continue.
So, and
so far, good?
Just getting together accidentally, like you're in one place and the other person, the other just walks in. That's not protected, but if as soon as they notice they should leave the place, is that how that works with the order? I don't know if you can hear me. There was some connection issues.
No, I can hear you. Very good question. Can you hear me?
Yes,
okay.
yes. There were a few breaks,
maybe.
but I think
okay.
Yeah.
Can everybody who's joined hear us?
Yes. If somebody says yes or give a thumbs up, that
or
would
I
be
should
great.
say if nobody can hear us, say something, but then they can't hear us.
I think there's 17 people here. Yeah, this is great. There. Oh, where are the superior courts in the area? So that's actually one of my questions I forgot to ask. How do you find the closest superior court to myself? Let's say.
Good. So you just think of county you live. No, that's a really good question. The way that it works is, so city of Seattle, city of Linwood, city of Redmond, all of these cities will have courts that are called municipal courts. So, generally Snohomish County, Pierce County, those counties is where the Superior Court will be. So there's no such thing as a Seattle Superior Court, technically. If you Google it, King County Superior Court will come up. But so Superior Court is generally, the only one too. So, you won't be confused, trying to find the right Superior Court. So whichever county you live in. So King County Superior Court is downtown. It's not the court on 5th Avenue because that's Seattle Municipal Court. It's the one on 3rd Avenue.
Oh.
But King County Superior Court is divided into 2 sections because of the population density. And so there's also a King County Superior Court in Kent. It's called Melling Regional Justice Center, short, RJC. So if you live closer to Kent, but you're still in King County, then you would go to, to the King County Superior Court in Kent, which is called Regional Justice Center. Snohomish County only has one. They're not divided. And then I think Pierce County only has one too. Does that help?
Makes sense. They're smaller counties, of course. Yeah. I think that was the only question so far we got from audience. Yeah.
Perfect.
Yeah. Makes sense.
So you can,
joining. Yes.
Yeah.
Sorry.
Yeah. No, thank you. It is sunny and so appreciate it.
Yeah.
So the last thing I had mentioned, excluding the person from wherever you are going to be, and to answer your question from earlier too. So what if you're both in the same place at the same time? Because I did say the abuser has to be in that place knowingly, right?
Yes.
That's something that you're just gonna have to gauge, right? But if they can't come close to like your school, your residence, your daycare. So if the person is driving, by in front of your house, I don't know how accidental that can be, right? So you just have to kind of use your best judgment and gauge it. If that happens, that person needs to turn around and walk away. So if they see you, they need to turn around and they need to walk away, right? Don't initiate in any conversation with the person. Don't try to start telling them that they need to leave. If it's safe for you to do so, then leave. If not, stay in that public place, where there's people around. But generally speaking, uh, I mean, that it's just kind of a judgment thing to prove that the person knows that they're there or not. Um, if you're sharing residence, and you put your address as the address that you share, and then as soon as the respondent, so the abuser, is served, and I'll explain what that means in a minute, but until they get served, until they get the paperwork, technically speaking, there's no order in place. So if you put the residents that you share together, they have to leave. You do not have to leave. Even if you're not on the lease, you do not have to leave. You can stay at that residence.
Are there repercussions of leaving
Able to get your
the shared
belongings.
residence, or?
It's not a question about shared
Oh,
residence. They're
sorry.
not asking for a copy of the lease. Yeah.
Mm-hmm.
Can you hear me?
Okay. So
Okay.
yeah, there was a little break
So
there. Mm-hmm.
So the court will not ask you to bring, a copy of the lease. The court will not generally ask you if you're on the lease. And so if that's the residence that you're sharing, then just putting down that address is sufficient.
Okay.
And if you choose not to stay there, but you want to be able to safely get your belongings, there is a place to say, here is the personal belongings that I would like, I would like to get back. Car under my name, cell phone,
Mm-hmm.
money, things like that.
Great. I'll continue.
There is,
Yes. Oh, sorry. Yes.
no, that's okay. We're almost, it's a long form, but there is a place where you can ask for additional requests, such as I want the person to get treatment. There is a place that you can mark where you can ask for the protection order to be effective for longer than what the judges will usually grant. There is even a spot for pets. So if you have shared pets, you can put that in there as well. If you're aware that the person has any firearms, you can ask for the abuser to return any firearms that they're in possession of. And so that adds a little bit of a safety feature. And so once the form is filled out, what happens? Either the same day or the next judicial day, which is, the next business day generally, you will go in front of the judge. Like I said, because of COVID, you will go in front of a judge and, via Zoom, and, all that information is provided to you, how to log in. And the judge will listen to you. The judge will basically say, explain to me why you need possible. And there is a section in the form as well where you're actually going to put in, there's lines where you can put in specific instances and why you think you need this. The more specific that you put it, the more credible it is, right? So I wouldn't something like last week he or she yelled at me and it made me feel uncomfortable. 2 years ago, he threatened to take away my phone, or she threatened to take away my car. It's very general when you say it like that. And so, what I would suggest is, if you remember the date, write down the date. If not, generally, what what time of the year or month. Was it daytime or nighttime? Where were you and where was he or she? What caused basically your fear that would lead to irreparable injury. The more you put into the form, the easier it is for a judge to not ask you, any more questions. And it's usually just between you and the judge. So the respondent, the abuser, is not there yet, right? If the judge grants your emergency order, then there's going to be a packet of paperwork and a new court date for the full hearing. So when you initially go and you initially appear in front of the judge, it's just you and whoever you choose to go with. But then there has to be a full order, because in the court's eyes, they have to be fair to the other side too, to be heard. They need an opportunity to respond to it. And from the moment that the judge grants your protection order ex parte, which means at that initial hearing, within those 2 weeks until the next hearing, the respondent, so the abuser, has to be served. If you go to superior court, the domestic violence advocates will help you with the sheriff's office. So you don't have to do it yourself. You actually can't do it yourself, and it's probably not safe, to do it yourself, even if you could. But the sheriff's office will take the packet. Where does he or she work, the respondent? Where does he or she live? And they will try to provide the paperwork to the respondent. Until that person gets served, the order is not valid yet, right? Because they didn't have notice, is what it's called. So if the person doesn't have notice, they don't know that they're violating it. 2 weeks later, you show up to the full hearing. And then the judge will check, was the other side served? The sheriff's office will usually submit something to the court, to you too, but a lot of times the petitioner may not know. But if the sheriff's office or whoever did the serving says, yes, I provided these documents to the respondent on this date at this time, it'll be a short declaration, then the person is served, which means the moment that happened, they know not to contact you, with all the things that were listed that the judge granted in the petition. If the person has not been served, the judge will, at the full hearing 2 weeks later, the judge will continue the case and say, let's try this again. Maybe we need more information, maybe we need different address, or, a little bit more information to make sure that we know where to find the abuser, the respondent. If the person is served and you're at that hearing, at that full hearing, and the respondent doesn't show up, generally speaking, you win. So the judge will find in your favor, and then the order will be in place for a minimum of 1 year. So for 1 year, that person can't come to the house, can't contact you in any means, even through third parties, like, he or she, as the abuser, can't tell, your best friend to tell you something. That would be contact. So if the person doesn't show up, then you win. If the person does show up, then it turns into a full hearing, basically. So at this hearing, it's almost like a mini trial, and it depends on which judge or which magistrate you get. Every court is different, every judge is different. So, there's no, one size fits all type of thing, but some judges will let you bring in witnesses. Some judges will let you have an opening statement and question the other side, and the other side will question you. And then, you will do your closing argument, and then the judge will make a decision. Other judges will say, I have reviewed everything. Everything has been provided to me, and I'm going to make a decision unless you have something to add. It's possible that the other side, so the respondent, shows up with an attorney. You know, don't be afraid if the person shows up with an attorney, because like I said, if you fill out the initial paperwork in as much detail as possible, you know, that's helpful. If they show up with an attorney, it's possible that, you know, they will ask for a continuance. And if the continuance is granted, so the judge allows it, the temporary order will still be in place, which means during that continuance, you know, the respondent still can't get in touch with you. But generally speaking, this is, you know, step by step, you know, how to submit the paperwork and how to do the initial hearing in court and the second full hearing.
So what I'm understanding, if somebody suspects he or she is in a domestic violence situation, that they should be actually writing down the dates and events happening. So it sounds like that will be really helpful during the hearing.
It's helpful.
Okay.
I would do it in a safe way.
So the next question is, are there, yeah, sorry, that was like a little connection there. Sorry. Are there resources that can help with the process? Attorneys, I think you mentioned domestic violence consultants in the Superior Court. Anything else that can help? Or people resources?
Yeah. Domestic violence advocates are, you know, they're free. They're provided to you at no cost. And even if they can't give you legal advice, they can help you, you know, fill out the form, you know, question 1, question 2, question 3. You know, there are attorneys who take protection order cases. Family law attorneys will generally also take them, especially if there's a custody battle. But just for the protection order hearing, I think the cheapest, just generally so people have an idea, the cheapest I've seen for attorneys to take these are around $1,000, $1,500, but it can go up to, you know, $8,500, or it can be done at an hourly rate. So there are attorneys. So if you Google domestic violence protection order, a bunch of attorneys are going to pop up on the screen in addition to the court information. So that's available. You can also Google pro bono representation, and pro bono means free of charge. So these big law firms who would generally charge, you know, $500-$600 an hour actually have a specific amount of hours that they dedicate to giving free legal advice. They don't get paid for it. There are some instances where they do, but I won't go into detail. But, you know, these are attorneys who will help, you know, represent you from, you know, the beginning until the end. And they will tell you step by step what documents to provide, you know, to help your case when you're filing for these. And that you can also just Google, you know, pro bono domestic violence protection order. I think the you know, Bar Association pages usually have it. King County Bar Association, Washington State Bar Association has some resources for these, and other legal areas as well. So not just specifically for this, but the resources are out there.
Great. There was a question about the forms, the location of the forms. I guess we can share them on the event page, or maybe when this is uploaded, wherever it's uploaded, we'll try to share the forms, because it's really hard to right now to share the video. I know. So yeah, next question: what if the petitioner does not speak very good English?
Which is why, you know, we felt strongly about providing the seminar too. I think that's the biggest hurdle, especially for, you know, immigrant women or men as well, who come here on a visa basis, or, you know, with their significant other, and the court will provide interpreters free of charge. It can be any language that they can do. If it's an, you know, specific tribal language, even there's a language line, national language line, that the courts can connect with, and the interpreters will help you with translating the forms. They will, you know, they can't answer any legal, you know, questions, but they will just translate what the words, you know, are specifically saying in the petition. They will also help with the hearings. So they will be present during the hearings and they will translate everything. So, you know, language barrier should not be an issue. We just need to let the court know about it.
All right. There was a few comments, ELAP. I'm not sure what that means. If you know, we can talk about it, but or we can maybe they don't talk with the commenters.
No, ELAP is great.
Is that another resource?
It's another resource. It's called the East Side Legal Assistance Program.
Okay.
Yeah, okay. East Side Legal Assistance Program. So, you know, it's another one of the resources, actually, yes, that some of my friends have participated in the program as well, highly qualified attorneys, and they can help with, you know, these kinds of cases as well.
Awesome. All right. I think we how many hearings does it usually take to this protection order? I think you mentioned it, but it's good to go over. What do you think?
Yeah. So so the initial hearing is called the ex parte emergency hearing, and then technically 2 weeks later, you have the full hearing. You know, at that time, it's determined if the other side has received the paperwork or not. But like I said, either side. So, for example, if the petitioner submits the paperwork, and then the respondent, the abuser in this case, will hire a lawyer, and then they show up to court with a lawyer, and then that lawyer will say, well, Your Honor, I would like time to respond to the declaration and everything that was submitted. Like I said, generally the judge will allow it, and then the case will get continued. And then it depends on what they will provide to the court. Whatever anybody submits to the court has to be provided to the other side. So, you know, technically, could it go on forever? You know, where, no, I want to respond. No, judge, I want to respond. No, now I want to respond. It doesn't happen like that, because usually after, you know, at the most the third continuance, which rarely happens even to the, you know, third continuance, the judge will say, you know what, put it on the record. Let's hear it. You know, respond now. But it has to be technically provided before the hearing.
Okay, great. Well, who is the petitioner and who is the respondent? I believe you answered that too, but yeah.
I wanna answer that, and so some of the things, you know, I appreciate that you're asking multiple times, because there's always, you know, as an attorney, I can always explain everything in all different angles, right? But you know, like I said earlier, the petitioner is the person who is seeking protection. The respondent is the person who is the abuser. A lot of times in domestic violence situations, especially, if the abuser is trying to control you, there are times where they will petition the court just to maintain that control, right? So there are cases where the petitioner is actually filing what's called a frivolous case. So it's a case that has no merit, it has no basis, because it could be another way to you know, control the behavior within that relationship. And if that happens, you know, unfortunately, you won't have access to a domestic violence advocate from the court. But in that case, what I tell people is, you know, respond to each of the allegation as detailed as possible. Again, so if they're alleging something happened on this date, but it actually happened in reverse, you know, people are not supposed to lie, but people lie, right? So if you're in that situation, support it with more information. What you can also do is, these are called declarations that you can get from family members or friends. So, you know, family members or friends who are aware of your situation maybe, or who just want to talk to, you know, write what's called, you know, they're basically letters. What makes it a declaration is on the bottom, you know, when the person signs it, they want to say, I declare under penalty of perjury that the above is true and correct. You know, that's specific legal language that you can provide, but anybody can write a letter saying, look, the petitioner is actually the abuser because I've seen it on multiple occasions. You know, I've spoken to her after, you know, incidents have happened. You know, the respondent is actually the victim. The respondent is a good person. If you have any questions or would like more information, here's my phone number or here's my email, and then you sign it, and then you know, you give that to the victim, basically. So with those letters, you're supporting, you know, everything that you're saying. You know, it's almost a little bit easier to respond to it as a respondent than as a petitioner, because you don't have to initiate anything. But it can be reversed at some points. And then in those hearings, you know, when you show up to the full hearing as a respondent, but you're actually the victim, there is something called requesting to realign the parties, which means, judge, I am the victim, but the abuser is posing as a victim. Can you please reverse the names on the petition? And, you know, if you've provided enough documents, then that can generally happen as well.
Wow, it's amazing how legal.
A lot of information.
Yeah, a lot of information, and it's really good to know. These are some things that you won't think that will happen to you. Like, oh, I'm the victim here, but all of a sudden you're in the, you know, respondent seat.
Yeah.
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 Okay. Can the respondent come to my home or work after receives the protection order?
He cannot. The moment that he receives the protection order is the moment that he or she had notice. And so they can't come to the home. There is something called a civil standby. And so if you live together and that person says, I need to go, the respondent says, I need to go and I need to get some stuff, right? Scary, right? You don't want, I mean, this person has just been served with a protection order and they're supposed to stay away. They have the right to a civil standby, but they don't have the right to do it at any time. It's generally done with law enforcement. So the sheriff's office will meet the respondent at the home at a pre-planned specific time. You don't have to be home. They will only have 10 to 15 minutes to go inside and get immediate belongings. So they're not going to carry out couches or, you know, TVs or anything like that. It's literally just immediate personal belongings that they can get from the home. So they can't come to the home unless they have a civil standby order.
Okay. I've just been informed that this might finish in an hour, like when the hour is up. I think you answered most of them. Maybe we can do another. We can do another one later on. Anyway, there's an audience question. What if the respondent didn't receive the order, but it was sent to respondent? I think it's yeah.
That's a good question. So it's supposed to be served in person, right? So you're supposed to serve the person, not you, don't do it yourself, but the sheriff's office will generally do it. And Sarah, to answer your question too, generally they do it within 10 days. If they can't do it within 10 days, then they will, you know, send it back and explain to the court why they couldn't serve this person. But it can't be done by mail unless the court approves it by mail.
Okay. I'm trying to see if any other information that we haven't covered yet, because of the time limitation of Instagram.
Yeah.
So what is the cost for these protection orders with or without an attorney? I think you mentioned with an attorney, it's varies a lot, but without an attorney, yeah. Can you speak to that?
It's free. It's free. Other protection
Great.
orders have a cost, and that's why I wanted to make sure that I mentioned that. I think anti-harassment order is $53 or $83 or something like that. But these types of cases are free of charge.
All right. Anything else you wanted to mention before we close up? Because I'm a little worried with the technology.
No, we do want to. No, we do want to leave some time for. Uh, uh, for. So what happens if the person violates it? Let me just speak on that real quick. You call 911.
Okay.
You contact law enforcement, right? Because then at that point it can turn into a criminal case. And so, you know, make sure that you don't feel that, oh, maybe this wasn't enough for me to make this call. If the person tries to contact you in any manner, it's okay for you to call 911.
Okay. Yeah, I think we pretty much covered all the questions I have here. Because I mean, you went into much more detail in some of the questions. So I think, yeah. COVID. I think you mentioned everything online now, which is probably more accessible. Any other closing remarks would you like to make?
I can answer any questions in, you know, a couple of minutes if anybody has any questions. But, you know, I appreciate that Turkcha provided, you know, to be able to share this information. You know, like you said earlier, I do, you know, generally criminal defense, so, you know, DUI cases or car accident injuries and things like that. But this is something that I've done before for a while, as both as a prosecutor and as a private attorney. But, you know, feel free to reach out to me if you have any questions. I'm not gonna, you know, take the case. I'm happy to answer any questions, and I'll make sure to provide our information, contact information as well.
All right. Thank you so much. Yeah, I think that will be all for today. And well, maybe we'll have more follow-up with Fatma. Thanks so much, Fatma, our own Washington's lawyer, and she's immigrant woman. Thanks for everyone for joining in this sunny, nice Seattle day. That's one of the rares. Well, hope to see you later. Bye-bye.
Thank you so much, Burcu.
Thank you.